Welcome to the National Crime Victim Law Institute's online toolkit. Toolkits, which include a combination of videos, downloadable resources, and other interactive exercises, are part of the larger universe of resources that NCVLI offers. In addition to these toolkit resources, you can visit NCVLI's website at www.ncvli.org to access additional free resources, including a number of in-depth articles in NCVLI's Victim Law Library. You can also visit our website to request additional technical assistance and trainings on victims' rights-related topics.
So I just want to start out by very quickly welcoming you again to this session, getting started and staying in the game, victim standing and ethics of representation. We're going to talk about standing. We're going to talk about victims' rights and strategy, and we're going to dig into ethics today. We always like to start a lot of our presentations with a slide like this because at the beginning of your work on any case, you might be told no, you might be told something can't be done, right? But you can still enter a courtroom with the attitude of an innovator. Your job is to say, yes, it can be done, and let me tell you how. That's what today is about, is giving you what you need to take that stand.
So we're going to give you some tools to feel confident and to be successful in doing this work. And some of them may be primitive, right? We might be going back to the beginning, all the way in law school and arguing basic standing principles. And some may be creative and innovative. But we want you to leave today knowing that there is a way to make victims' rights meaningful and that you can get in the game and stay in the game to help victims have a voice during the criminal justice process. And some of those most basic tools are the victims' rights. And every jurisdiction has victims' rights laws. And really the key here is you need to know what your rights are in your jurisdiction. And you need to know where they exist, in the Constitution or in statute or both, and then to know the scope of the rights. We're not going to go over the rights in detail because that would take a really long time, and they vary in jurisdiction to jurisdiction, so it really wouldn't be applicable to everyone. But we want you to be familiar with the basic rights found in most jurisdictions. And what are those rights? So let's just quickly go over them. So there's the right to fairness, dignity, and respect. We kind of like to refer to it as the due process right. And this is all encompassing. And really, we like to use it as kind of additional support for a lot of our requests that we make for the court. Think of it as kind of when your gut tells you that something isn't right, like the victim's not being treated right. And then you can look to this right, in addition to just general due process principles. And then the right to privacy. And this is one of the most litigated rights for victims. It's big. And the focus of the next session is going to be on privacy. So don't worry, you're going to get lots of it and very helpful information in the next session. The right to confer with the prosecutor. And this can be regarding the plea or other important decisions about the case. The right to notice. This is a gateway right? If you don't have notice about proceedings or what's going to be happening in the case, victims can't take advantage and exercise those other rights. So it's really key. Notice is one of the key rights that come up a lot when there is a violation, and it's because they didn't have notice. Right to be present. Surprisingly, before this right this existed, victims were excluded and forced out of the courtroom, even when their own cases were being decided. When you look at the laws in each jurisdiction, the burden to exclude a victim is really high. So therefore, you should almost always have this right afforded and be able to successfully argue that the victim should remain present if that's what the victim wants. The right to be heard. This could be at release, sentencing, or plea hearings. This is more, and this is what we want you to kind of take away from this right. It's more than just the victim making the statement. It's more than just your traditional victim impact statement. It's the right to be heard through counsel, which includes filing motions. So think of it as a really big, important right. The right to speedy disposition. The longer a case drags on, the more harm to victims that can occur. And this isn't the right to dictate when necessarily a case is going to be done, but it gives them the opportunity to argue during delays and continuances, right? Argue for timing of proceedings, et cetera. It's just to make sure that the court is stopping and taking notice of the victim when they're setting the case docket. The right to restitution. We all know crime has a huge financial impact on victims, and this right is so important to ensure that victims are made whole. So when we go through this, these rights are crucial because what they mean is that victims have a role in the game, right? We're talking about getting in the game. This is how they get in. They have a role. These are rights of participation, right? They're not merely observers anymore, and they're not just pieces of evidence. And to be a player, keeping with the game analogy, you need to know the legal definition of victim so that you know that your client falls under that definition, is entitled to these rights and entitled to have a seat at the table. And because victims are new to the game, you're going to have to probably assure the parties and the court that these are rights of participation and not equal to party status, right? Victims are not coming in to control the case. We're not trying to usurp the prosecutor's role or to team up on defendant, right? What they do, what you are there for, though, is to independently exercise your rights and, if necessary, to enforce those rights. You'll get pushback. You'll be told that you don't have standing to file that motion, but these rights are the tools to get standing, to get in the game. And we want to never take things for granted and always be ready with trial and appellate level standing, ready to argue that you're there and that you are rightfully there to be in the game. So let's talk about standing, since it's so important. Guarantee, and for those of you, again, with experience, you can share your experience as this, but there will be a time in your career representing victims that standing will come up, right? They'll argue that victims don't have standing to be there. They don't have standing to file the motion. And the strategy here that we would like, the NCVLI likes to take in arguing for standing, is that it's a non-question. Of course, victims have standing. I think it's really key for us as victims' rights attorney to really take on the attitude for some of these challenges that we're faced with, that's not an issue, because it isn't, right? And I think this more we can forcefully reinforce that and make everyone kind of see that it's not an issue to be argued, the more victims become just an actual player in the game, right? It's not an issue. So for standing, it can be explicit in law, or it can be based on the prudential test for standing. Legal victims, right? So if you meet the definition of victim in the law, you have rights that afford standing. So walking into court or talking to the defense attorney or the prosecutor, we want you to be confident, to be assured, to be like, yeah, of course victims can file this motion. Of course my victim can be heard on this issue. So how do we do this, right? Well, standing is fact specific. And you want to ask yourself, does this victim have standing at this moment to assert this right or to request this remedy? And break it down. So as mentioned earlier, it can be explicit in statute. So looking to the Federal Crime Victims' Rights Act, that's an example of an explicit standing. And it reads, the crime victim or the crime victim's lawful representative and the attorney for the government may assert the rights. Straightforward. It goes on to say the district court shall take up and decide any motion asserting a victim's rights forthwith. And if denied, the Court of Appeals shall take up and decide such application for remedy forthwith with 72 hours that the petition has been filed. So right there you have explicit. That's going to be obviously not an issue, we hope, when you're in federal court and you have the explicit standing, but it shouldn't also be an issue if you don't have explicit standing, because we have, going back to law school, right? We all go back to our first year of law school and the test for standing. We can, with victims' rights and when they're at stake, you can meet the necessary tests for standing. So staying in the game requires mindfulness, right? We have to be ready with trial level and appellate standing. You need to be thinking about what rights at stake, what you're asking for, and being ready to go into court to argue that you have standing. And you may still hear the refrain, victim is not a party, right? Well, you don't have standing. You can't file that victim's not a party. Well, that's a red herring. Standing is not the same as party status. And for example, the media files motion in criminal cases all the time. They have a First Amendment interest at stake, and that gives them standing. And similarly, victims have various rights at stake during the proceedings as well. So be prepared and be confident to argue for standing, and that will get you in the game. We're going to talk a little bit more about that.
That's right. So we're going to pound the pavement now and think about what this looks like really in practice. Let's start with the first step of a notice of appearance, and really want to emphasize that this is a notice, right? This is not a motion. It's not asking the court to do anything. It's just, we're making a statement of appearance on behalf of the victim. And we're notifying all parties and the court that the victim is now represented by counsel. It's common practice in a lot of jurisdictions, including federal, to include a general assertion of rights in the notice. So that's something that we want to get used to. If we're thinking about strategy here, it's going to depend a lot on the jurisdiction and the state of law. We want to consider whether we want to file a blanket notice of appearance with or without that assertion, or whether we want to wait for clarity of rights and ripeness. We will recognize that there are some not so great cases from lower courts in some spots, like New York trial level, or even in Florida at the Court of Appeals, which is being litigated right now. But want to take that as an opportunity to let you know that NCVLI is always available for technical assistance when you come across those kinds of issues. As we move into the next step of motion practice, the strategy here is really just, let's be preemptive. Let's be proactive. You're going to get a lot of pushback when you're trying to enter the game, like Terry said. So we're going to think ahead as much as we can about victims' rights issues that really might materialize down the road, or how can we respond strategically to current issues, like let's think about meeting medical record requests with a motion to quash. A strategy here could be to proactively protect privacy by contacting the record holders and letting them know ourselves, hey, if you're subpoenaed, notify us, please. And then you can respond to that subpoena by providing documents under seal to the court with a letter stating that the victim is going to challenge this. So it's really just thinking ahead and thinking practically about what the case looks like now and what it might look like. Looking to appellate practice, the jurisdictions are going to vary here. Some of them explicitly direct a particular appellate device for victims' rights violations. So, for example, in Arizona, there's a special action. Oregon has an interlocutory appeal. And in Oregon, the law literally states that appellate order, review of an order described must be initiated by filing a notice of interlocutory appeal with the Supreme Court substantially in the form prescribed by rule of the Supreme Court. Review of the order is a matter of right. So this is under ORS 147.537, section 1. So this is the kind of thing that we just need to be aware of as we are stepping into a different jurisdiction and thinking about what appellate practice looks like where I am and where I'm practicing. Right? These are the big forms of relief that we talk about a lot in victims' rights. So when you're asking the court to stop, more often than not, it's somewhat similar to a request for an injunction. For example, telling the court to stop what it's doing and address the victim's rights issue in the moment, or asking the court to stop a party from doing what that party is doing and address that victim's rights issue right then and there. However, you could also ask the court to stop by seeking declaratory relief, an appeal, or a writ of mandamus. These remedies really don't exclusively belong to the stop form of relief. So when you're thinking about seeking a do-over, you can also proceed there by a request for reconsideration, special action relief, or just an ordinary appeal. In some jurisdictions, there are money damages. That's something to be aware of. And in other jurisdictions, there's a move towards this. So keep an eye on that as we think about this. But regardless of what the remedy is and what the relief is, we're going to really just make sure that we're focusing on reintegrating the victims into the criminal process. It's about that agency. It's about that empowerment.
And then getting into the game and representing crime victims, there are a few ethical issues that are commonplace. Not every case will have them, but they're easy to predict and to prepare for if you know what to look for. Some examples of issues that commonly come up: conflicts of interest with current clients. Many cases have multiple victims, and we'll discuss that a little later in this session. Communications with represented individuals. Victims now have attorneys representing them, right? And how does that mean with prosecutors? And we're going to talk about that right now. And then competence, right? This is a new area of law. So we may need some training to be able to represent competently, which is what we're doing now. So let's take a closer look at one of these issues. And I'm going to read the slide. You have filed a notice of appearance in a criminal case. Your client is the victim in the case. At a pretrial status hearing, you leave the courtroom to make a call. When you return, the victim tells you that the prosecutor approached them and asked them to think about a potential plea agreement and whether he would be amenable to a plea agreement that did not include prison time. The prosecutor told the victim that this conversation was not an official conferral and that she was just trying to gauge the victim's position. So, our question for you is, in thinking about this, is, did the prosecutor violate any rules of professional conduct in communicating with that victim? So let's go ahead and look at the rule. And the first thing we want you to note is that this is the federal rule, model rule. In some jurisdictions, which are very similar to this, many of them copied them, but some jurisdictions will use the term party in place of person that we have in here. But we want you to know that generally this has been interpreted to mean person, so not just the party to the case. So when we're looking at this rule, and I'm going to read that out loud, communications with persons represented by counsel. In representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or a court order. So what information do we need to know to better analyze the scenario just presented? Is there other information that we need? So I know one thing that I would want to know is potentially what's the scope of the representation? Am I representing, did I agree to represent the victim maybe solely on, say, like a restitution issue only? And that's the only thing that I am representing them on the case? Or do I have a general representation agreement where I am going to be representing them for the entire case? Because this may be outside the scope of representation, maybe not, but that's something to be thinking about, right? Knowing whether or not this is going to be something that is covered by your representation. Does it make a difference if the victim had walked up to the prosecutor and asked about the plea agreement, or the prosecutor was not the one initiating, it was the victim? And the answer is no. So the comments to the rule say that this applies even though the represented person initiates or consents to the communication. A lawyer must immediately terminate communication with a person if, after commencing communication, the lawyer learns that the person is the one with whom communication is not permitted by this rule. So you may get, and a lot of the people, when they hear that the victim is represented and this rule might apply, they get concerned like, well, how is the prosecutor going to do their job, right? The victim is their key witness. How are they going to go ahead and do their job if they can't speak to them? Well, that's not the case, right? It's not that you can't speak to them. It's just that there is, attorneys navigate all the time communicating with other attorneys when they're about their clients and what they want to do and what they need to have conversations and to speak. So there just needs to be an agreement, right? You need to talk with the prosecutor about what is acceptable for communication. Maybe notices from, of certain proceedings can go directly to the victim. That may be okay. It may be okay if they talk about status or plea if you're only representing on the restitution issue. So you have that, you have that conversation, and then it's very easy and maybe even better if notification and communication goes to you because it's consistent. They know your address, they have your contact information. And so it's just easy. It's simply a way of ensuring that the victim's voice is, the victim's interests are protected and that your representation is honored. It's not about limiting what the prosecutor can and cannot do with that victim. It's just merely respecting the fact that just like any other person who's represented by an attorney, a victim has that same relationship, and it's extremely important that that relationship is respected. And so moving to the next slide, and I won't go over this in detail, but the rules, there are some examples, case law or ethics rules where this rule has been applied. And basically it comes down to if there is a civil case that's based on the same conduct as the criminal case, this rule applies. And so the prosecutor shouldn't be reaching out to that victim in the criminal case if they have representation in the civil case on the same, that relates to the same conduct. And with that, we're ready to move on to more rights related issue.
That's right. So please be ready to stretch your brains and think critically, because this is our chance to really dig into these conversations together and think about what we see, what we would do, and really consider these issues that we're going to talk about. So we're going to start with this issue here, and I'll read the slide. The first section says, a domestic violence victim seeks your assistance. The abuser was arrested and taken into custody. The victim is terrified that the defendant will be released on bail pending trial, right? We're thinking about fear of the defendant being released. What do we think about here? What is something that we could do? The defendant was released at arraignment when the victim was not present. The victim talked to the victim advocate in the prosecutor's office to see what could be done. The prosecutor got back to the victim and said that the judge is not going to hold the defendant without bail, and that the defendant has an ankle bracelet on to alert police if he leaves his residence. So taking this a step further, what can you do?
What rights would be the tool for standing to get into court to ask for whatever it is that we're interested in asking for on behalf of this victim? What rights are at play here? And Connie said right to be informed about the release. What other rights?
Looking just even at that first piece, right? Getting ahead of it before the release would be maybe even filing a motion asking for release conditions. And the strategy there would really be to just making sure that we're independently asserting what the victim needs to feel that safety that you all have identified that's needed, thinking broadly, thinking outside of the box, and really considering all options on the table at this point. So whatever that need is for that safety, that's what we want to think about. Once you know what that is, then we want to see, how can we fit this request into the law? How can we talk about this request with the court? And really understanding and knowing your jurisdiction's laws, including case law, is going to help so much, right? That's going to make you better equipped and give you the most tools at your disposal to really craft your argument. So for example, in Vermont, the Vermont Constitution does not allow for a defendant to be held without bail. So we want to be sure to address that, right? We never want to come off or risk creating an impression that we don't understand or know the law. We want to come off as educated as possible, and definitely as educated as defense attorneys and as prosecutors. And really thinking about this right off the top, working with a prosecutor to come up with joint release recommendations is always a great thing if you can do that in this kind of situation, right? We want to, of course, independently assert your own motion or a joint motion where it's appropriate, but even though this is a great idea as an option, we're never just going to rely on a prosecutor to do it alone, right? We want to make sure that we're preserving that standing. We want to make sure that we have that standing for appeal. So we want to make sure that, collaboration coming up, working with a prosecutor to come up with a joint release recommendation, that's great, but asserting it on our own, that's so huge. And really looking for the next section, again, the strategy, using all the laws, that's including the rules of criminal procedure, that includes your statutes. The court's inherent authority is one that we talk about a lot, just to get that do-over. What rights are violated here, right? The violation of a right to be heard, as you all said, protection was the big one, the right to confer possibly, which is something that some of you pointed out, and then of course, the right to be treated with fairness, dignity, and respect. We always have the option to file a motion to reconsider. So you might get what you want out of that. But if it's denied, there's no doubt that the issue is ripe for appeal. We want to talk to the prosecutor, of course, and see if they will agree that a violation of rights occurred, and they would maybe be willing to join a motion to reconsider with you. We're going to make our legal arguments the same as you would have done, for the above section, for why the new or changed conditions are necessary here, thinking about that safety. And, an example of this is the victim had the notification of an ankle bracelet go directly to her home in this one case, and the police, because that would give her time to get to safety. So it didn't just notify the police, it also notified the victim if the convicted person and with the ankle bracelet were out of the vicinity where they were supposed to be, or if they were close to her home. So in this situation, it was something that made sense to do that because the police were too far from her home, and the defendant would not be able would have been able to get to her home before the police could have actually notified her because the defendant was so close. So thinking about our victim situation, what gives them that sense of safety is so huge. And staying in the game is going to always require independent assertion of the rights to have standing on appeal. So if you're not filing something independently and you're joining that prosecutor, we still want to make sure that we do this because it's the best way to ensure that we stay in the game. Anything else to add to this one, Terry, before we move on to the next slide?
No, and I other than just, asking the victim, what do you need to feel safe, right? It's about victim agency. And again, this can be tied in with those protective orders that we talked about, but there's no reason why you don't ask the court for those, right? Independently going in and asking in the criminal case for the motion for release conditions.
Absolutely. Thank you. So we're going to look at this one here, and there's going to be, you're going to probably notice some restitution issues going on here, but we're going to, as we read through this, look deeply at the facts in this scenario that hit on the ethical issues. So this slide, the issue is the defendant was convicted of burglary based on breaking into an apartment and stealing property. 2 men lived in the apartment. Both men lost items in the crime. One of the men, Victor, could not sleep or find any sense of peace following the break-in. He paid to have an alarm system installed in the apartment and started seeing a therapist. Victor's health insurance does not cover the counseling costs. Both roommates come to your office seeking assistance. The prosecutor said that she was not going to ask for restitution because the defendant was indigent. She told you to apply for victim compensation. After looking into victim compensation, they were told that compensation does not cover property loss, but could cover Victor's therapy. Okay, so there clearly are some restitution issues here, but let's think about this ethically. What we're going to ask you, the big question here, is can you represent both roommates? And again, we want to think about this and enter it into chat. So let us know in chat where you stand on this, 1, 2, 3, or 4. So this is model rule 1.7, talking about conflicts of interest and working with current clients. And what information do you need? It's going to be, what do you need to provide information and review all potential consequences?
There might be an answer that you can come to that says it's ethical, but then there's other issues, at play that maybe that's not still the best way to go about it.
Absolutely. And we need to sit on the client's consent, right? That's the apostrophe in victims' rights. So, we want to also think about consequences, but self-assess, right? Whether with their consent, can we provide uncompromised representation to both of them? Here, for example, restitution might not be as difficult to represent both of them as in some other instances. If it's truly just, let's obtain this order for full restitution, and then you're not going to assist them with collection of restitution, right? So it's a limited scope of work. However, you need to explain to both people that they might be ultimately going after the same pot of money. And at this point, you might have to withdraw because collection might be impossible to do for both. So this is really important, whether clients understand that limited proceeds may limit what they each recover, totally going after that same pot of money. So this can get really tricky. And, that's why a lot of times it depends, I need more information is a good one for these types of responses, because these are conversations we need to think about. And looking at the model rule here, we're really paying attention a lot to, is this representation ever going to be directly adverse to the other client, right? Thinking about significant risk, thinking about concurrent conflicts of interest. These are the things that we want to be sure that we're considering in these real life circumstances. Let's talk a little bit more about working with scenarios where there might be more than one victim. Sure.
And we brought this up because this is an ethical issue that frequently presents itself in representing victims. And it's really 2 reasons that this comes up. And one is, as we know, a crime can have multiple victims. I mean, unfortunately, mass shootings have become commonplace, environmental crimes, etc. And even something like domestic violence, you may have the spouse and then a child who witnesses the act, who may be also a victim. It's also common for a single criminal act to affect a direct victim and indirect victims, such as parents and family of a homicide victim. So you have if the direct victim is a child or is otherwise incapacitated, others may also be victims. They may step in the shoes, family members, as I just mentioned, guardians. You need to look at your jurisdiction's definition of victim to determine if that indirect victim actually steps into the shoes of the victim, or if they are a victim on their own, for their own sake, and can exercise their rights on behalf of themselves, not just on behalf of the victim. So it's very common that you can have these situations where you will have these conflicts that can potentially arise with multiple victims. And these, such as some examples of those would be when you're conferring with a prosecution regarding like the sentencing. Like some victims are going to potentially want a much harsher penalty than maybe another one. Release recommendations, right? Maybe one victim doesn't want the defendant released at all, but the other wants them released so they can work and provide for the family, or et cetera. Sentencing recommendations, as I was just mentioning, but restitution as well, right? Like we were just talking about. But one thing where this really comes into play, and it's the difficulty arises, is when we're dealing with really small rural communities where there aren't a lot of options for victim representation, right? So you may have to be taking on these multiple clients, but you can only do that, and you should only do that if their consent is, based on clear understanding of what conflict could arise and the consequences. So this is just another instance of one of the ethical issues that could come up in cases. So now we're going to go over our final hypothetical here and kind of brainstorm what rights can get us in the game and what we might do in representing this victim. So the defendant pled guilty to stalking and the trial court sentenced him. Following the sentencing, the victim, who had requested her rights, learned that the defendant had pled guilty. She did not attend the plea hearing because the victim advocate had told her that it was just a status hearing and that she did not need to be there. The victim comes to you. She is upset because she had wanted to be present at the sentencing and to be heard. Right to provide victim impact statement. Yeah. Right. She wants to be heard. So can we do that? Right. We've already had sentencing here, folks. Right. We had the plea agreement accepted, and then we had sentencing. Randall said I'd ask for a do-over. Yeah, exactly. What we want you to be doing with when you go into court with these rights that you have that have been either you want to assert, you want to exercise them, or you want to enforce them, is to think, okay, what does the victim want and how can I get it? And don't limit yourself. Don't be thinking, oh, this can't happen, or, oh, I don't want to step on the prosecutor's shoes. At this moment, you want to be thinking broadly. You want to be thinking, what do we want and can we accomplish it? And so for here, this victim wanted to be heard. And looking at the laws, probably not be able to get the conviction undone, potentially, depending on your jurisdiction. You may be able to argue that the plea was unlawful because the victim wasn't heard. But even if you can't, right, maybe you can ask for a sentencing, right? So ask for a resentencing so that she can be heard, even though the plea was already accepted. This is actually a case in Oregon. The Oregon Supreme Court found that the law required a remedy for this violation. And while they couldn't undo the plea, they could set aside the sentence and do a resentencing so that the victim could come in and be heard. And so I think the strategy here that we want you to be aware of is to act quickly on a violation. Rights of participation are ephemeral, right? You can lose them if you don't act. And in helping the victim to stay in the game requires acting quickly to notify the parties in the court that there was a violation and that you're pursuing a remedy. So you want to get in there and act so you don't lose those rights. And another thing to be thinking about is even when it seems like, wow, what can we do here? There's nothing to be done. The plea, and the sentencing's happened. No, victims' rights have changed the game, right? This is new. And in Barrett, in the Oregon Supreme Court was like, well, this is what the law says. The law says there should be a remedy. And so what can we draft that's not going to violate defendants' rights that can be a remedy? So think broadly and be confident in going in and asking for these things. And using those tools, those rights to get in there and really making sure the victim's voice is heard, what they want out of the goals that they want, and really pursuing that. So we have some final pointers. These are just general to all of it, right? And we want you to walk away with these kind of big themes in your head. And one is, you can't do this alone, right? Nobody can do this. We all work with a variety of relationships to help victims get through the process and to seek justice and to end up, more whole, trying to get back to being whole again after this victimization. So building relationships with others who do the work. So other colleagues, we've had some people who've been doing this work, sharing their thoughts, and they have knowledge. Reach out to them. NCVLI has resources. NAVRA will be sharing information about that, where you can reach out to us if you have a question. You're like, you said we could do some of these things, but I'm not sure how. Reach out to us. That's what we want to do, is we want to help you. And build relationships with prosecutors and victim advocates, right? They're the ones who are going to be dealing with victims and can refer. And also, a good relationship with the prosecutor is going to make those joint motions much more likely to happen. And then anticipate what might come up in a case and file preemptively. Be proactive, right? Like we talked about some issues that you can think about that might come up, ethical issues that might come up. Also think about rights issues that might come up. If you're in a sexual assault case and the victim's been going to therapy, be thinking about the potential for their records to be subpoenaed. And then think outside the box and think big. I think we've already been reinforcing this, but the sky's the limit. Victim law is new. We should be reaching for the stars and asking for what the victim needs, right? We shouldn't be hesitant. The most the court can say is no, and we can challenge that. And if the upper courts say no, that's nothing lost. But if we don't seek it, then there's no way it's going to happen. So I think the think big is what we'll leave you with here.
During this section, we worked hard so that we could look at standing. We could learn about common victims' rights and strategies for litigating them and identifying some potential ethical issues. You got this, and you're not going into it alone. Terry?
Leaving on you got this, I think, is the key. I think that's what we hope you take away from this is this can be done and you can do it.
Thank you for participating in this online experience, and we hope you enjoyed it. If you enjoyed this tool and are interested in other victims' rights tools, please visit NCVLI's other Toolkit resources for additional interactive learning exercises like this video, in addition to other tools such as flashcards, tip sheets, and much more. One of NCVLI's key projects is the National Alliance of Victims' Rights Attorneys and Advocates, NAVRA. Using its updated website, www.navra.org, NAVRA connects people committed to improving the justice system by providing the practical tools they need to protect, enforce, and advance victims' rights. NAVRA's tools include searchable databases of sample legal pleadings, legal memos, and key case summaries, as well as in-person and online trainings, partner listings, and the pro bono portal, which matches attorneys with crime victims in need of representation. And in addition to these resources and others available on our website, NCVLI is ready to assist by providing additional research and assistance that is tailored to your needs. Please visit www.ncvli.org and navigate to the online form by clicking the Professional Resources tab and then selecting Technical Assistance. Thank you for joining us.